In this session, I will be discussing administrative discretion and its judicial control. Due to complexity of modern times, wide discretion has been conferred on officials to make a choice as to when, how, whether or not they will act. This is indeed required to handle intricate problems associated with present administrative setup, which involves investigation of facts, making of choices and exercise of discretion before deciding upon what action to take or not to take. However, sometimes the wide discretion leads to its abuse or misuse. The objective of this session are to understand the meaning and concept of administrative discretion, highlight the need and importance of discretionary powers, and study the grounds of judicial control of administrative discretionary powers. Let us first understand what discretion means. Discretion in layman's language means choosing amongst the various available alternatives without reference to any predetermined criteria, no matter how fanciful that choice may be. Like a person writing his will has such discretion to dispose of his property in any manner whatsoever. It might be arbitrary or fanciful. But the term discretion, when qualified by the word administrative, has somewhat different overtones. Discretion in this sense means choosing from amongst the various available alternatives, but with reference to the rules of reason and justice and not according to personal whims. Such exercise is not to be arbitrary, vague and fanciful, but legal and regular. If we look at the executive functions, these can be classified as ministerial and discretionary. A duty or power with the administration, the exercise of which involves no element of discretion, is characterized as ministerial. In such cases, the law prescribes the duty to be performed with such certainty as to leave nothing to the exercise of discretion or judgment, like maintenance of birth and death register, execution of a warrant, etc. On the other hand, discretionary power is a power to choose amongst alternative course of actions. In functions like acquisition of property, regulation of trade, industry or business, investigation, search and seizure, destruction of property, detention, all depend upon the subjective satisfaction of the authority, and a lot of discretion is involved. The modern administration has conferred very large discretionary powers on the administration, which is to be exercised on its subjective satisfaction. Without the relevant legislation laying down clearly the conditions, circumstances, norms subject to which the executive is to exercise the powers. The power of administration are thus couched in very broad formulae. It is the authority which has to choose amongst the alternative course of action for good reasons to be justified by the authority. The central feature of discretion is a degree of autonomy within a defined context, which is vested in the decision maker. The discretionary function making is thereby subjected to the requirement of rational decision making. Thus, when we speak of administrative discretion, we mean that a determination may be reached upon the basis of consideration not entirely susceptible to proof or disproof. Legislations are usually drafted in general terms. They leave large area of choice to the administrator to apply the law to actual specific factual situation from case to case basis. A statute confers discretion when it refers an official for the use of his power to beliefs, expectations or tendencies instead of facts, or such terms are used like adequate, advisable, appropriate, beneficial, competent, necessary, practicable, proper and reasonable, etc. The legislation does not specify clearly the conditions and circumstances subject to which and the norms with reference to which the administrator has to exercise his powers. Now, here the problem arises. Where discretion is absolute, man has always suffered. Administrative discretion is more destructive of freedoms than any of the man's other inventions. Therefore, the need arises that the discretion has to be exercised according to rules of reason and justice, according to the law and laid down principles of law. Thus, legally there is nothing like unfettered discretion, which is immune from judicial review. There can be no such things as unreviewable discretion. The control of discretion is needed to maintain a rule of law society. The judicial control of administrative discretion thus reflects reconciliation of two conflicting interests. On one hand, the absolute powers of the administrator to exercise discretion and take the decision without interference from the court, and on the other hand, there is a need to keep the authority to act within the bounds of law so that the common man does not suffer due to the arbitrary action. Thus, judicial review of administrative discretion is a reality and is exercised at two stages: at the conferment stage by deciding about constitutionality of the statute, and at the actual exercise stage by deciding the validity of the administrative action. At the conferment stage, the court may compel the legislature to desist from conferring too broad or uncanalized discretionary power. The courts control the bestowal of discretion to some extent by testing the validity of law in question at the touchstone of fundamental rights. The conferment of arbitrary, uncontrolled discretion without any justification or reasonable classification has been held violative of right to equality under Article 14, fundamental freedoms enshrined under Article 19, and procedure established by law under Article 21 and 22 of the Constitution, and it has been insisted by the courts that the legislature should set up a standard or lay down a policy or principle subject to which administrative discretion may be exercised. Now, coming to the control at the stage of exercise, all will agree that there is a need to have some post-decisional review mechanism also to ensure that administrative authorities discharge their function according to law. The exercise of discretion is reviewed on two broad grounds. One is abuse of discretion, other is failure to exercise discretion, and these two categories, however, are not mutually exclusive. In one sense, the exercise of discretion may fall under failure to exercise. In the other sense, the same may have been exercised on irrelevant consideration, thereby constituting abuse of discretion. The failure to exercise discretion results if the authority does not decide or does not exercise the discretion one way or the other. A discretionary power must in general be exercised only by the authority to which it has been conferred. Delegation of discretionary power to a subordinate authority without statutory authorization and the exercise of the same by subordinate is bad in law. Further, where the authority concerned acts under the dictation of another body and disables itself from exercising the discretion, it is a ground for failure of exercising the discretion. When discretion is exercised mechanically without applying one's mind to the facts of the case, or where the authority is expected to decide each case on the merits by scrutinizing them from case to case basis, and it puts restriction on the exercise of its own discretion by announcing the rules of policy to be applied rigidly, this becomes a case of failure of exercise of discretion. The second category, abuse of discretion power, may arise due to mala fides, where the motive force behind an administrative action is either personal animosity, vengeance, benefit, friendship or relationship. It may also result when the exercise is for improper purpose. Statute gives the power for one purpose, it is used for some different purpose, or when the authority takes into irrelevant consideration in exercising the discretionary power. Sometime while taking decision, the authority leaves out relevant consideration or exercises discretion partially on relevant and existent consideration and partially on irrelevant consideration. It may sometime also happen that there are unreasonable exercise of power. The discretionary power is to exercise reasonably, fairly, non-arbitrarily. The courts have ruled in a number of cases that they should quash administrative action if no reasonable person would have reached to such a decision. So friends, in this session I have tried to briefly touch upon the administrative discretion and its judicial control, the various grounds on which the judiciary exercises its power. With this, I end my session and leave you with some basic questions which you will be able to answer with ease now. Thank you very much.